Hi, everyone. My name is Archi Pyati. I'm Chief of Policy at the Tahirih Justice Center. I'm going to be talking with you today about a decision that came down in an asylum case yesterday, which is absolutely devastating for asylum-seeking women who are fleeing domestic violence around the country. First of all, a little bit about me, and then also a little bit about Tahirih Justice Center. So the first thing I'll say is that I am very nervous doing Facebook Live videos. I'm going to do my best today because I think it's very important that we talk about this critical decision and that we have that we begin dialogue as a community, as a nation, on what are we going to do to counter this decision and to try to regain our moral authority and begin to comply with international obligations. So I'm doing my best today. I will watch to see if there are comments or anything else that I can see. Looking at my screen, I don't know if I'll be able to see them. And so if I don't see any, I'll just keep on going. I am an attorney and I've been practicing law for about 17 years. I began my career in the post 9/11 era working with asylum seekers who were being detained after the terrorist attacks on 9/11. And I spent a lot of my time in detention centers in New York City, meeting with individuals who were being detained and deported. So I began my career in a dark place and really trying to work to provide some kind of information, knowledge, background, representation, if and when possible, to individuals who are being detained and deported in that scenario. I worked in that environment as the Department of Homeland Security was being formed and as the Bush administration did what it could to restrict some areas of immigration, but also did quite a bit to uphold others. And during that time, believed I was fighting a very uphill battle in working on behalf of immigrants. I will say that nothing I experienced in that era, in that environment, could really have prepared me for how devastating the situation is now. I think even last year, when you saw our CEO, Layli Miller-Muro, doing Facebook Live videos and talking to you about executive orders that were coming down, I don't think any of us really imagined we would end up where we are today in terms of how we are treating those seeking asylum in the United States. I work at the Tahirih Justice Center, and for those who don't know, Tahirih is a national organization with offices in 5 cities around the country, on the West Coast, the East Coast, and the South. And we provide free, high-quality legal and social services to immigrant women and children who are fleeing domestic and other gender-based violence. In addition to our services, we do provide, policy advocacy here in Washington, D.C., and as Chief of Policy, I oversee that work up here in Washington. So yesterday, many of you will have seen in the news that yesterday we did have a decision issued by the Attorney General in a case called Matter of AB. And the case itself was shocking. The case is shocking. It's of a woman whose initials are AB, who experienced extreme violence at the hand of her domestic partner and came up to the United States to seek protection. And after applying for asylum here, was not granted by her immigration judge in North Carolina, but appealed the decision to the Board of Immigration Appeals, where she was granted asylum. In fact, the Board of Immigration Appeals didn't grant her. We call it the BIA, Board of Immigration Appeals. The BIA actually said she does merit asylum and sent the case back to the immigration judge saying, since we find that she merits asylum, we ask you to do some further fact-finding and then let us know. And then please issue a decision in her case as the immigration judge. At that point, her case was pending in front of the immigration judge and nothing further happened beyond that until this year when Attorney General Jeff Sessions certified the case to himself That means he took the case from the immigration judge and reviewed it himself in order to make a decision as to what he thinks should happen to Ms. AB. Now, why and how can the Attorney General do that? Well, the Attorney General is, works for the President and is underneath him in the Department of Justice. There is the Executive Office for Immigration Review, in which first sits the Board of Immigration Appeals, and just below that are all the immigration courts across the country. So any case that an asylum seeker files, she may file it with an asylum officer, which is a different set of adjudicators altogether. But eventually, if she ends up in front of an immigration judge, that immigration judge is technically under the Department of Justice. Then if anybody, either the government or the applicant, appeals, she goes to the next level, the Board of Immigration Appeals, also under the Department of Justice. And then at the top of that is the Attorney General. So the Attorney General technically has the authority to pick up a case from the courts and take a look at it. But there's a question as to whether the Attorney General really has the authority to take a case from an immigration judge when a final decision has not been entered in the case by the immigration judge. The case was still technically pending. And so the Attorney General, in the past, we've always seen Attorneys General, when they have certified cases to themselves, they take the cases from the Board of Immigration Appeals, a final decision, and they think about that. Or they take a case that is pending in front of the Board of Immigration Appeals, and they think about that. This was a very unusual situation, and one that gave many people pause. And even to this day, the argument still is valid, I believe, that the Attorney General didn't have full legal authority to take this decision from an immigration judge and begin to consider it himself. Okay, so we have now a decision yesterday from the Attorney General. So what happened between the time when the Attorney General certified the case to himself and yesterday when he issued the decision? What happened in the meantime was that a lot of organizations got very concerned that the scope of the Attorney General's inquiry could be quite broad, partly because the question he asked was very confusing and very broad. I'll explain more about the question and about the scope of the decision and exactly what it touches in a minute. But what a lot of organizations did was jump up and say, we're very worried about what this means. And so attorneys for the applicant, Ms. AB herself, continue to file briefs with the Attorney General. And then a lot of organizations like the Tahirih Justice Center filed what we call amicus briefs, that is, briefs that explain why we care about the decision that might come out of this case. We organized a lot of coalitions to get onto our briefs, so did others, and we filed these cases, these briefs with the Attorney General. So what we saw yesterday was the Attorney General's decision, having considered briefing from the Department of Homeland Security, considered briefing from Ms. AB and her counsel as well, and then considering briefing from 13 parties who submitted these amicus or friend of the court briefings. The Attorney General then issued his decision yesterday. So the decision that he issued ultimately, it has a couple different components. Now, one component is that he decides that he believes that Ms. AB does not merit asylum, and he now sends it back to the immigration judge to make that decision. So he completely overrules, essentially, the decision that the Board of Immigration Appeals made, saying that she does merit asylum. The other thing the Attorney General does, and I think this is where I want to spend some time really explaining the decision, is he goes through an analysis here, sort of marches through a lengthy analysis, really, of who should qualify for asylum, and makes a decision that women fleeing domestic violence should not qualify for asylum in most cases, and then explains why he thinks that in many pages, and overturns a precedent-setting case from 2014 that announced that all women seeking asylum based on domestic violence may qualify. So I want to spend a minute here talking about how many people are we discussing? Because I think a lot of folks struggle with what is called the floodgates argument, right? Are we talking about tens and hundreds of thousands of women around the world? Many of us who pay attention to domestic violence, who think about domestic violence, who work in this area, know that domestic violence is an epidemic. It plagues women in the United States, and it plagues women around the world. So if we say we want to offer asylum to women facing domestic violence, are we talking about potentially hundreds of thousands of women, maybe millions of women from around the world? Are we saying we think all of them should come into the United States? The answer, according to existing asylum law before yesterday's decision, was no. We actually had a pretty narrow framework. It wasn't even a door that was open. It was a cracked window, really, a very small opening for women who met very specific criteria to come through and be able to seek asylum and be able to merit asylum, frankly, under the adjudications. And so what that criteria is what I'll describe now, and then we'll talk a little bit about how the Attorney General now goes against all of that jurisprudence, really, with his decision. So let's start really by talking about what is asylum? How does somebody get asylum? What are the grounds for it? You know, after the news erupted yesterday about this decision, people have been reaching out to us and asking questions about, I thought asylum was only for political actors. I thought asylum was only for certain kinds of people with religious backgrounds. No, asylum actually begins in a treaty, in an international treaty called the International Refugee Convention for short. Believe it or not, it has a much longer name than that. And the treaty establishes, it was written after the Holocaust, and establishes that governments really have an obligation to invite those who are fleeing persecution to apply for asylum in their home country, in their countries. So in other words, the United States, which has ratified the protocol to this treaty, which means it's bound by it, has promised all the other countries of the world that if an individual comes to this country and tries to say, I'm a refugee, I need asylum, we will provide a process for that, and we will give that person a fair shot at seeking asylum. The definition for asylum for a refugee in the Refugee Convention has then been taken out of the convention, the treaty, and dropped right into our domestic immigration laws. Those domestic immigration laws are, have been around for a couple decades now, and the definition really just says this is who may qualify for a refugee. There are parts of it that are not terribly specific, and so over the last several decades, attorneys like me and others around the country have been fighting and fighting and fighting to better understand and explain through litigation exactly who might qualify. So what is the definition? The definition of who is a refugee essentially is somebody who's outside their country, so somebody who's left and is, let's say, somebody in the United States who is asking for protection and expresses a credible fear. They have to be afraid of something. They are afraid of experiencing something called persecution. It's a term of art, it's a legal word. Persecution has to be a serious kind of harm. Usually it's not something purely economic, something not purely verbal, but usually persecution is a serious kind of harm, a threat to your life or your liberty. Or possibly other, a threat to your dignity, your human rights. Those are things that may amount to persecution. When somebody says, I'm afraid of persecution, it could be because they've experienced in the past, or the persecution could be something they fear happening in the future. So the person has to fear persecution. The persecution needs to be on account of one of 5 grounds: race, religion, national origin, political opinion, or membership in a social group. Now, people call it political asylum sometimes. It's really a misnomer because we're really talking about any kind of asylum protection offered to somebody fleeing persecution on account of those 5 grounds: race, religion, national origin, political opinion, and membership in a social group. The final thing that's really worth talking about today, there are many other factors, but the final factor, primary factor, is that the persecutor, him or herself, needs to be either the government of the country the person is fleeing, or someone the government cannot or will not control. So what does that mean to us? That could be, reasonable people could have a debate and a dialogue about what that really means, who qualifies. And so that's exactly what has happened. So Congress has offered some guidance. There are rules that have followed from the Department of Justice and Department of Homeland Security that offer some guidance. Then there are policies that have been developed through memos and trainings and things like that over many years by those government agencies. And then finally, there's litigation. And through litigation, each individual asylum seeker's case becomes a proving ground. If you are going to grant this case, you may be creating a ground for other people like her to benefit from asylum. So as you heard me say, the 5 grounds, social group is one that has been less clear. The words itself, it doesn't really mean a lot to many of us. And so there has been litigation on the basis of individual cases over the last several decades to try to explain what a social group means. In addition, the treaty itself has a governing body, the United Nations High Commissioner for Refugees, and the High Commissioner for Refugees has issued its own ideas of what social group means. And it's important to say right now that the decision issued by Attorney General Sessions yesterday definitely goes against everything that the United Nations for High Commissioner has suggested should be grounds for asylum. So let me move along now. Who merits asylum under the social group definition? Social group is not, as you hear it, necessarily gender. Some would argue, and in fact, Harvard University argued in the case of Matter AB as one of the amicus briefs I mentioned at the beginning of this broadcast. It is possible to argue, and I think a valid argument and one worth making, that gender itself should be considered a social group. But that is not what jurisprudence typically has said. And nobody said it can't be, but typically what judges have been deciding is that it should actually be, we should be defining what is a social group based on how society sees us. So if I am married to a man and that man is abusing me, and that abuse amounts to persecution for the sake of argument, and I approach the police, or I don't bother approaching the police because I know they won't help me, and what happens in the police or the government in general is that I am viewed as belonging to my husband and therefore not relevant or important to others as to the government to protect, then that can be a social group. So a social group can be defined as women who are married to their spouses are being and cannot get away from them, defined partly as being unable to get the help of the government, that you are being unable to get the help from the government that should be helping you. So right there in the social group, right, we have a sense of that it can be women. It can be women who are in domestic violence situations. It shouldn't be defined by the domestic violence, but it's not. It's defined by her specific life situation, which she can't change, and for which she can't get any help. So that's what we had. And in 2014, after many years of litigation, I was involved in some of this back in the early 2000s. Now, in 2014, we had a case which said, matter of ARCG, which said very clearly that a woman who met very specific criteria and fulfilled the definition of a refugee, so somebody who can say that she has been or is afraid of persecution, who can also say that persecution took place because of one of the 5 grounds, including defining herself as a part of a social group that is prescribed in these particular ways, then also can demonstrate that she is from a country where even if her persecutor, her abuser, is a non-state actor, the government will not and cannot control this persecutor. She qualifies for asylum. Now, still, it's important to share that only about 20,000 people are getting asylum each year, and that's overall with all categories. So a small proportion of that really is getting asylum based on gender, and then even within that, a very small proportion is getting asylum based on domestic violence. So we're not talking about more than a few thousand a year. We're not talking about tens and tens of thousands of people who are getting asylum based on this every year. So it's already, like I said earlier, a very narrow window that that current law, that the law as of yesterday, prior to yesterday, was providing for. So this decision that was written, and distributed yesterday in matter of AB goes very far. In my view, it really overreaches. So I stated at the beginning that there's a pretty strong argument going around out there, and I believe it's right, that the Attorney General did not have the authority to take the case in the first place and issue a decision on a case that was sitting and pending in front of an immigration judge. That's number one. Number two, some of the decisions, some of the scope of the decision he makes in his written opinion is very broad, and I want to explain why it's broad. And the third thing I want to talk about now is that he not only is what he's saying very broad, it's very poorly reasoned. And it demonstrates a lack of understanding of domestic violence and the social constructs and the political lack of will that we see in many countries to actually intervene and protect women. The patriarchy, the misogyny, the way that the government structure is, the way that there's very little training, there's very little resources to law enforcement. There's no, like I said, political will to actually stop domestic violence. In those kinds of contexts, we have to take that context into consideration when we look at whether somebody should qualify for asylum. And Attorney General Sessions' decision does none of that. It doesn't look at any of that context, and it doesn't reason through any of it. So very briefly now, let's talk about what's wrong with his decision. Number one, he overrules matter of AB's grant of asylum from earlier from the BIA, which I disagree with. I think as somebody who's experienced severe domestic violence, who's defined a clear social group, and who has 100% demonstrated that she's credible, there's no reason to have denied her asylum. Number two, the Attorney General overrules matter of ARCG, that case from 2014 that I mentioned, that establishes that women can seek asylum and be granted if they are fleeing gender-based violence, in particular domestic violence. He overrules that decision as well, which is broad. I mean, that's a decision based on a lot of factual analysis at the immigration judge and the Board of Immigration Appeals level. It involves briefing from different parties around the country. And he just waves his magic wand and overrules the whole thing. And so in doing that, what is he saying? What is his reasoning? So at Tahirih Justice Center, we're very worried about this because almost all of our asylum clients, about 30% of our cases at Tahirih Justice Center are asylum cases. And almost all of them, all of them are gender-based asylum cases, and almost all of them rely on matter of ARCG. What I will say is that there are a couple points I'll raise right now, and then I'll sign off, and I'll come back on again in a few days to give you more updates and information. But right now, what I'll share with you is that one area, so I talked to you about what the government's role has to be. The government has to either be unwilling or unable to protect the individual. In this decision, the Attorney General wrongly makes a leap and states that if the persecutor is a non-state actor, the harm must be attributed to the government. That is a huge leap. We never said anywhere that the harm had to be attributed to the government. That never happened. So that's one problem. The other big concern is that the Attorney General seeks to drastically narrow what it means to define a social group, and says, in fact, that I almost laughed when I read this. If I hadn't been crying when I was reading the decision, I would have laughed when he said that prior judicial interpretations, now under the Bush administration and the Obama administration, many judges have interpreted the definition of a refugee to include women and children who are fleeing domestic violence and other forms of gender-based harm. He says that prior judicial interpretations of the phrase particular social group are no longer relevant. Because if Congress had wanted to tell us what social group should be, it wouldn't have left it so ambiguous. Now remember, at the beginning of this video, I shared that Congress left it the way it was because it was picking it up from the treaty and dropping it into our law. Congress did not make a specific choice not to explain that. So, or they did, but they did it because they were mirroring the treaty. So here he's saying Congress left it ambiguous so that an implementing agency could simply interpret it. In other words, he believes that he has the right and the authority to simply decide, after decades of jurisprudence, after decades of judges have said one thing, that he wants to say the opposite, and that that should apply to everyone around the country, all judges and all asylum seekers. And there are a couple of other pieces. He also states that, and this is the part that is really infuriating, in fact, when you think about the dynamics of gender-based violence in particular, that a non-state actor, in the decision in ARCG, the BIA was wrong because what she experienced, which everybody believed, nobody thought she was lying. If we all believe that what she experienced, that should amount to persecution, the severe beatings she had lived through. And he says, the Attorney General says, that harm in ARCG was not persecution because there was not enough evidence to support the finding that the government condoned the abuse. He says there may be many reasons why a particular crime is not successfully investigated and prosecuted. He doesn't go into any kind of reflection as to what some of those reasons might be. Doesn't bother to consider the fact that we know exactly why the government in these governments in many of these cases do not investigate or prosecute domestic violence. It's because there isn't the political will to do so. It's because the society, the community does not believe that a man who abuses a woman to the point of physical violence and potentially sexual violence should be prosecuted, and that the law should protect women, their rights, their right to safety, their right to their lives. And so because the Attorney General does not go into a deep analysis there, he simply writes off scholarship, lived experience of survivors, what jurisprudence in the immigration field itself says, certainly amounts to a good reason why we should look at a woman and say, even though your abuser might not have worked for the government, might not be a government official, the fact that he's abusing you in a country where nobody is prosecuted, where when people are making complaints to the police are sitting on their hands, we know for sure that you merit asylum. In this case, the decision, the Attorney General has just issued a decision wiping away all of that knowledge, all of that information, and declaring that that's not enough to merit asylum. Throughout, the Attorney General looks back at other decisions that came years ago before his tenure as Attorney General and simply writes off the information, the decisions, the facts provided, though he clearly doesn't have, he doesn't necessarily have the record in all of these cases. He can't look at the evidence. He's not able to say, and doesn't say, I've reviewed the evidence in these cases, and I can say that there is evidence, that there's not enough evidence. In fact, in Miss AB's case itself, the case whose decision we're talking about today, she had 700 pages of information and evidence to support her claim that she was abused and that her country would not protect her if she were there right now, and she would be suffering from persecution. So my conclusion for today is to say to you that yesterday's decision is momentous. It is a truly heartbreaking and very, very dark and sad day in America when our Attorney General issues a statement, issues a decision that reaches so far and so broad to say that that domestic violence victims who are claiming asylum, who fit the definition based on the statute, based on the rules and the policies and the decisions judges have made for the last several decades, that none of that applies anymore. For example, in his words exactly, the asylum statute does not provide redress for all misfortune. It's a very sad day when our own Attorney General doesn't understand what the asylum statute is there to do, how narrow the door is that is being provided to women seeking asylum, or how important asylum is to protect the lives of these women. Even worse is that he does understand it, and that this decision was written the outcome of this decision was preordained, that regardless of what briefing any of us had done, regardless of what stories we had told or the facts of ARCGs, ABs, or any other woman's case, there was a political motivation or a personal biased motivation, let's say, to come into this decision and say that women cannot get asylum when they're fleeing from domestic violence. It's not entirely unreasonable. We know that Attorney General Jeff Sessions, when he was a senator, voted against the Violence Against Women Act. We know that this administration has called immigrants crossing the border animals. We know that it is systematically cutting away at due process in the courts. It is systematically cutting away at and undermining other protections offered to women who have been abused, even here in the United States. We know that it is separating families at our border. Our own staff in our Houston office have been down to the border, have seen the conditions in which families are being held, have seen mothers and fathers ripped from their children. We know that folks who are coming across the border very clearly are being separated from their children as a way of dissuading them from seeking asylum. So in this context, it's no wonder we got a decision like this. It's nonetheless heartbreaking and shocking that we've come this far away from the ideals that led the United States to ratify the protocol of the Refugee Convention so many decades ago. We've come this far away from our values that have the Statue of Liberty standing at our shores. We've come this far away from the values that help us understand that we are a nation of immigrants. We are a nation built on the principle that European settlers came because they were looking for safety from protection, from persecution on the basis of their religion. Some did. And now we have our own Attorney General that we've elected into office saying that we don't stand for that anymore, that we don't stand for the protection of women, we don't stand for the upholding of international law, and we don't stand for rule of law in general. So again, it's a very sad day. We are working hard at Tahirih Justice Center to raise awareness. We are working hard to educate members of Congress and ask for their help in holding the Attorney General accountable. We would like the Attorney General to revoke his own decision, and that is our number one ask right now of the Attorney General and of Congress as they communicate with the Attorney General. And we would also like to begin further litigation. We'd already been working on issues like this, but for all of our clients now and all of our potential clients, we have so many individuals that are going to need our help appealing every single individual decision and getting us to a place where we can really be litigating the issues that are at stake here. And we need your help. So my last point on today's call is to ask you to please take action. We have sent out an email through from Tahirih explaining action points you can take. Please reach out to us. Visit our website, www.tahirih.org. Visit us through Facebook. We can connect you. You can receive our emails so you can get up-to-the-minute updates on decisions like this that are affecting our nation, our society, and what we stand for. I think the test of who we are as a community, no matter what our political persuasion is, no matter whether we are Republican, Democrat, independent, whether we vote or don't vote, the test of who we are right now as a community and as a society is going to be whether we raise our voices on behalf of the women and children who need us right now. So I encourage you to join us and I welcome you. Thank you very much for paying attention today, and we will give you more information through videos, emails, and other updates as we go forward. Have a good day.